A routine court appearance quickly turns into a tense dispute between a defendant, his public defender, and the judge. The defendant claims there's been a complete breakdown in communication with his legal team, argues that mistakes affected his bond decision, and asks the court to replace his attorney. But as the hearing unfolds, the judge reveals information the defendant says he didn't know, creating an unexpected twist that changes the direction of the proceeding. Watch closely because every statement made in this courtroom plays an important role in what happens next.
Aware of that. Okay. All right. What are we doing in this case of his?
Your Honor, before we get started, I believe Mr. Ross would like to address the court.
Mr. Ross.
Yes, Your Honor, there's a breakdown in communication between me and my current counsel, as well as the public defender office. At my arraignment, I was denied bond. The arraignment was for an alleged bank robbery charge, and the public defender used MCR 6-106B to deny me bond. Based on his rules stating that I've been convicted of
So that the public defender did that?
Yes, and not Mr. Lauren Brown, but the public defender's office, that the public defender that was assigned to me did that. And based on that,
denied you bond?
the magistrate denied bond after they used the Michigan court rules, sir. Okay, so after that happened, stating that I've been convicted of 2 or more violent felonies in 15 years, and this was not true. The public defender failed to just simply look on MDOC Otis and seeing that I only had 1 violent crime. Also, with my current and present counsel, I haven't been able to put any input or insist in my own defense. I requested motions for discovery and full disclosure, and as well as the custody order, and neither one of these motions are frivolous. Also, I've asked for any type of paperwork concerning my case, and just until 36 hours ago, I was just notified that the 3rd-degree home invasion charge was changed to B&E. That's part of the breakdown in the communication.
I don't know that, sir. Go ahead. I'll let you finish.
Yes, and I understand and comprehend that I'm not entitled to have the attorney of my choice, but also I'm unfortunately indigent and I can't afford to retain counsel. But the Michigan Constitution, United States Constitution said I have a due process right to have assistance of counsel. So I believe that there's good cause that exists where there's clearly a difference of opinion.
At this point, the defendant is making what's commonly known as a request for new appointed counsel. Simply disagreeing with an attorney isn't always enough for a judge to approve that request. Courts generally look for evidence that communication has broken down so severely that it could interfere with the defendant's constitutional right to effective legal representation. The defendant argues that he hasn't received discovery, wasn't properly informed about changes to the charges, and believes these issues prevent him from participating in his own defense. The judge now has to determine whether these concerns justify replacing counsel or whether the existing attorney can still provide effective representation.
Your Honor.
I sent you a letter requesting this.
20 seconds? Okay. Yeah, Mr. Brown, go ahead if you want to respond before I do. I just want to, I don't know if Mr. Ross even knows this. He's got another case before me that your counsel's filed a motion to protect your interest in the case. And the court has already gotten a prosecutor's response and we've set it for hearing. So that's interesting, these people not working for you. But go ahead, Mr. Brown, go ahead.
If they're not working, I didn't say they wasn't working.
You know what? You know what? I didn't say you. I said Mr. Brown can go ahead. Mr. Brown.
Thank you, Your Honor. Your Honor, the court should be aware that we put several man hours into this. We've had investigators going across downtown Ann Arbor seeking evidence and information on this case. I've spoken with Mr. Ross several times, twice visited him, spoken to him by phone, and spoken to him with a video conference. Mr. Ross believes that he cannot work with our office, and his belief is affecting our ability to be able to work for him in a zealous manner. So we are working for Mr. Ross. He doesn't believe that's the case, but I think that belief is the real thing here. That's going to cause a problem with our continuing to be able to zealously represent him, as he feels that his opinion on how things should be done.
Now the courtroom dynamic shifts. Defense counsel explains that investigators have already spent significant time working on the case and emphasizes that the office has communicated with the defendant through visits, phone calls, and video conferences. However, counsel also states that the defendant no longer trusts the public defender's office, making the attorney-client relationship increasingly difficult. Trust is a critical part of legal representation because effective defense often depends on cooperation between attorney and client. The judge must weigh both perspectives while deciding whether the relationship has truly become impossible or whether the disagreement can still be managed without appointing new counsel.
Not one piece of paper from the public defender's office concerning either charge.
So let's see. I don't have his bond as denied in this case. Is it the other case that it's denied?
In the bank robbery, yes.
Yeah, that's not before me today.
Yes, it is, sir. How is not? I got two cases.
Why? What? Hold on a minute. You're going to tell your attorney what to do, and then you're going to tell me what to do.
I'm not telling nobody.
Or what I have.
You should have two cases. You have
Listen to me. That case, your counsel filed a motion to protect your interests. I just said it to you. The problem that you're having is you're not listening. Mr. Brown filed a very detailed motion with this court that this court reviewed, requested a response from the prosecutor. The prosecutor filed their response. This court immediately set that case because of partially the bond and the issue that Mr. Brown brought before the court. I set that case for hearing. What date, Miss?
The 22nd.
The 22nd at 2 p.m. So, sir, no, that case is not before me today.
So, Your Honor, what I'm saying
Are we
I don't have any of
understood?
this information. I don't know any of this. I haven't seen the motion.
Well, now you do.
It's horrible.
Here's what we'll do. We'll just make this easy for everybody. What time is that other one set?
2 p.m.
2 p.m.? All right. Court is going to find good cause to adjourn the probable cause conference in this matter. I will adjourn it 1 week out.
In the end, the judge does not grant the request for new counsel during this hearing. Instead, the court decides to continue the proceedings, coordinate both of the defendant's pending matters, and schedule them together so the issues can be addressed more efficiently. Throughout the hearing, the judge repeatedly stresses the importance of listening carefully to courtroom proceedings and understanding what motions have already been filed on the defendant's behalf. While the defendant maintains that communication with counsel has broken down, the court concludes that the existing legal process should continue for now, with additional hearings to address the outstanding concerns. What do you think? Should the court have appointed new counsel, or was the judge right to move the cases forward as scheduled? Share your opinion in the comments below. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and turn on notifications for more real courtroom cases and legal analysis.